There is still time to get your questions in using that Q&A tab that I mentioned earlier. But this first one, Bill, it dropped in during your segment, so perhaps you want to lead us off with this. But Chris, you're more than welcome to chime in if you like as well. But Bill, how do you respond to lead counsel when they insist they are the, quote, client, and therefore there's absolutely no need for you to ever contact their actual client who is a named party that you're acting as local counsel for? So just to repeat that question, apologies to the person that submitted it, butchered that question there. How do you respond to lead counsel when they insist that they are the client and therefore there is absolutely no need for you to ever contact the actual client who's a named party you're acting as local counsel for?
Thank you, Andy. Actually, I will always ask, whenever I'm asked to be local counsel, I will always ask the lead counsel about client contact. I won't even wait until have them have an opportunity to say, hey, listen, I'm the client. You don't need to talk to the client, et cetera, et cetera. I always want to know up front, because if they tell me, listen, I am your client, you don't need to talk to the quote unquote client, I always remind them, hey, listen, the rules don't distinguish between local counsel and lead counsel. And your activity and actions in this case will ultimately reflect on me and my firm. So I need to, take precautions to protect us if anything, doesn't go well down the road. So, I first will remind them that the rules don't make a that they don't distinguish between lead and local counsel. And then I'll tell them, all right, that's fine. I understand, you don't want us to contact the client. We will treat you as the client. And then in my engagement letter, I will clearly spell that out and remind them that, listen, if I'm only going to be doing certain things, I put that in the engagement letter, and I insist that they confirm that they have spoken to the client and have obtained the client's informed consent regarding my limited scope of involvement in the case, and then I put that in the letter as well. That is the one way that you can always protect yourself and your law firm from any problems down the road. So if a lead counsel brings that up at the outset of our representation of them, I do the same thing. I say the same thing that I say when I have to bring it up to lead counsel, because I want to make sure that that's something that's clear, that, hey, listen, if something, if there's a problem and I need to talk to the client, and is there a contact person, and they tell me, no, you just deal with us. That's how I handle it.
I'll jump in too, and Bill, I think that's certainly spot on. The first thought in my head is always, what does the client think about it? How can we communicate and consult with the client on this? And that's in any representation, right? But particularly here, I think that's always good to head it off right at the beginning, so that you can initiate that and talk about client contact before it gets brought up to say, hey, we don't want you to have any contact with them. But then, as we've kind of reiterated throughout, it's really important to make sure that's very clearly documented, to the effect that, to the extent that you get pushback on that, and, the lead counsel is insistent that there's no communication. So I think that's really important to document, and I think Bill nailed it very, very clearly as to how, what that agreement would look like and what's spelled out, and the fact that lead counsel sought, informed consent, from the client to be able to engage local counsel in that manner.